This video was made to help you understand the protection order process. The footage in this video represents Minnehaha County. Please note that there may be variations in what you see in your community. There are two different types of protection orders. There is a domestic violence protection order and a stalking protection order. A domestic violence protection order is for anyone fearing imminent or physical harm from a relative related through blood, marriage, or adoption, or if you have a child together or have lived together. A stalking protection order can be used when someone has been repeatedly harassed or threatened, or if there is physical injury. You don't have to be related or been married, but this person has to have caused you physical injury or made threats to do so. Protection orders should not be used to solve personal property division or child custody issues. If these are issues for you, please talk with an attorney for assistance. Free legal assistance can be obtained at the East River Legal Services or the State Bar Association's Pro Bono Project. When completing a protection order, you are the petitioner and the person who has abused you or is harassing you is the respondent. To get a protection order, you have to go to the courthouse of the county in which you or the respondent reside. The hearing will be in the county in which the petition is filed. Mark the boxes on the first page that are appropriate to your situation. I am asking the court for a protection order based on the following facts. In this space, describe your most recent incident. Put the dates and times as close as you can remember. When describing the details, be sure to explain what happened in detail, how many times this has happened in the past, and when it has happened, why you are afraid and need the court's protection. It is very important the court understand the seriousness of your situation. Feel free to attach extra pages to describe what has happened to you. Use detail to explain to the judge exactly what your situation is and why you are afraid. Remember to ask for what you want from the courts, including temporary custody of minor children, visitation, work, home, or other addresses you frequently go and want the respondent to avoid, no third-party contact. This means their friends or family cannot contact you, whether by mail, email, phone, or in person. You can request a protection order for up to 3 years. If the abuse has been ongoing, you should request the full 3 years. A temporary protection order lasts until your scheduled hearing, which may be 30 days. Then at the hearing, a judge will decide the long-term length of your protection order. The judge will set a limit of the distance the respondent needs to stay away from you. Ask for a distance you are comfortable with. Once the petition is completed, take it to the clerk of court's office. The petition will be presented to the judge by the clerk. The clerk will notify you when to check back or whether the temporary order has been granted. If the order was denied, you may want to seek legal assistance. East River Legal Services provides free legal services. If the temporary order or notice of hearing was granted, you will need to pick up the protection order from the clerk. You will get 1 certified copy to keep with you at all times, and 2 for the sheriff's office so the respondent can be served with the papers. Once at the law enforcement center, tell them you have a protection order which needs to be served. They will direct you to the sheriff's office on the 2nd floor. You will need to give the respondent's home address, work address, and any other places where the respondent could be found so that the order can be served. The sheriff's office is required to contact you once the respondent has been served if you give them your contact information. If the sheriff's office is not able to serve the protection order, you still need to attend the scheduled hearing. The judge will likely continue the order if there is a good chance the respondent will be served in a reasonable time. You need to be present at the time to get the continuance. After the protection order has been taken to the sheriff's office to be served, you will need to begin preparing for the hearing. Talk with witnesses and see if they will attend the hearing with you. Gather written evidence of phone calls, letters the respondent has sent, medical or doctor reports, missed work, pictures of bruises or marks, police reports, a log of time and date that things happened, etc. You have the burden of proof. This means it is your responsibility to bring these to court to help prove your case to the judge. In preparing for the hearing, you may also want to contact East River Legal Services, the Rape and Domestic Abuse Center, or Children's Inn. Before court, you will want to arrange for childcare. Do not bring your children to the hearing. Volunteers of America provides childcare for court appearances. The courthouse has metal detectors and other security systems. Please come early to allow yourself time for this and not be late for your hearing. It is best to leave cell phones and anything else you don't need in your vehicle. You will be required to turn your cell phone off. Camera phones are not allowed in the courthouse. The court insists people dress in clothes that are not revealing. You should wear a shirt or sweater that covers your stomach. Pants, slacks, or other nice clothes are also encouraged. The courtroom is open to the public. There will be other protection order hearings scheduled at the same time. If the respondent is there when you arrive, sit in a location where you feel safe. Representatives from Children's Inn or the Rape and Domestic Abuse Center are usually present for support during the hearing. If you need support, please seek their assistance. The court will take attendance. Make sure the judge is aware that you are present so they don't dismiss your case. When your hearing is called, you will go up to the tables in front of the judge. The clerk will swear both parties and all witnesses in. The judge will ask you to explain why you are seeking a protection order. The judge may ask some clarifying questions. If you are seeking a stalking order, be sure to stress the repeated acts of the respondent. If you are seeking a domestic violence protection order, be sure to stress your past physical harm and fear of physical harm reoccurring. The judge will be granting or denying your order after hearing all the evidence. Direct all of your comments to the judge. The judge will give you a chance to challenge the respondent's version of events after their testimony is complete. If the respondent isn't present, the judge will ask if you still want the protection order. If you do, the judge may ask further questions before making a decision on the order. Once a protection order is granted, the judge will ask you to wait briefly until the clerk can get certified copies for you. The clerk will bring you a certified copy and ask you sign that you received it. If the respondent is present, the clerk will do the same with the respondent. If the respondent did not appear, the clerk will give you an extra certified copy to bring to the sheriff's office to have served. Follow the same steps at the sheriff's office as described in completing the temporary protection order initially. If you are afraid to leave the courthouse by yourself, ask the sheriff deputies in the courtroom or at security to escort you to your vehicle. If your protection order is not granted, don't give up. You still have options. You can call the Children's Inn, the Rape and Domestic Abuse Center, or East River Legal Services for safety planning or follow-up legal action. If abusive behaviors continue, contact a support agency and they may be able to provide resources and options. Once you have received a protection order, it is very important that you report all violations. Read your protection order to be clear on what is considered a violation. The order will explain what contact is not allowed. Call 911 as soon as possible to report any violations. Some violations could be telling you to drop the order, third-party contact, coming to your home or work, or threatening you by mail, email, text messaging, or any other type of communication. Remember, do not erase any of these messages. Save them all for further court action as evidence. If you are uncertain if something is a violation, call law enforcement and they will advise you. We live in a small community and there is a chance you may see the respondent in the same place you are. Do not approach the respondent. The respondent is forbidden to approach you. If the respondent does, the safest option is to leave and call 911.